Let me make a very short introduction into our next subject, and I will be very brief. So in this section, we like to discuss intellectual property rights-related issues. We will have Catherine Trautmann making the introductory remarks. I will just say very few topics and just setting the scene. And Marc Berejka will follow and will make some remarks from the US side. So what is, I think it's important to keep in mind, and this is the background, the setting. Our companies, all of our companies in Europe and in the United States and globally, most of them are companies which actually have a very intensive integrated transatlantic market. And most of them actually are definitely the global operating companies, independent, which sector they're coming from, media sector or the search engine or the social media or all of the other companies are global companies as well. So it is very important, of course, to understand that the intellectual property framework, where it is coming from, was very much nationally driven. But in a digital environment, it's not always easy to handle, to handle the item in the same way like we have done in the past. The digital environment is, of course, a challenge in many ways for certain sectors, that's the issue actually we face right now. So when you look at what is going on in the European Union, the situation is even a little bit more complicated. Pilar mentioned it very briefly in her introduction remarks on privacy, because we do have, of course, an European oversight and in many ways European legislation which are driving the issue. Nonetheless, in many areas and with regard to many topics, member states are still responsible in certain areas and the national law is applicable. That's very important to keep in mind, and the situation differs with regard to this situation to the United States. That's one of the reasons why the European Commission actually is looking into setting a new idea, a new framework, what is called the single market for intellectual property rights, and it continues with the slogan, boosting creativity and innovation. It's a very long title. I will not bother you with the title, but the basic idea is really to understand and to set a framework for intellectual property rights in the European Union right in the sense that it is as European as much as possible, right in the sense that it reflects the international need for the companies and even for many citizens operating, and it will be in certain areas, it will continue to respect national frameworks. Now that's a very challenging approach. And of course, because of this very challenging approach, we see clashes, which are natural clashes, because we are in a phase of transition in the digital environment. We see natural clashes, and I have seen them 15 years when I was in the parliament, between the various operators, because it is different if it's a search engine which is looking into intellectual property rights related issue, or telecom, or an ISP provider which shall suddenly carry liability related issues which they have never done in the past, or a Time Warner. We have Claudio Mori here from Time Warner, or you name them all. I mean, you know this world as much as I do. But for the European Union, it's a cornerstone to get the issue right. Now, what are some of the important issues? It's cross-border problematic. I mentioned it. So the cross-border problematic will continue. But I think the Commission, and more particular, I'm very hopeful that the European Parliament will get this right as much as they can and as much as the power allows all operators to set a new framework going beyond national possibilities. I would recommend to you to look into two documents which are highly interesting with regard to this, to understand the discussion in the European Union. One is the Hargrave report done in the United Kingdom, which really, the report is out, and I really recommend you to read it, because the conclusion is from the UK government that the IP environment which we see right now and everything which relates to the intellectual property rights environment is not fit for the digital age. Ireland is doing right now in the process of doing their consultation, very similar to what the UK has done, and the consultation, if I'm not mistaken, will be concluded today. One item which relates to this, it's the so-called update of the Enforcement Directive on Intellectual Property Right. I leave all of the points to Catherine Trautmann to say more in detail about it. And one final point, which is the balance, to get a balance right between strong intellectual property rights and the so-called fair use doctrine, or what we call in Europe the exception and limitations. What we see from the United States, and we discussed this intensively, and a discussion which will come over to Europe very soon, is the Protect IP discussion in the Senate, and what we heard yesterday from Goodlad, that it will be debated a similar approach in the Congress. Now we do have some concern. Again, I'm just referred to Catherine Trautmann, who will look into this issue. You need to keep in mind that the background of our operation between the European Parliament and the Congress is to some degree, in this area, not always very well defined yet. It's the Transatlantic Economic Council. Some of the issues which we discuss here are already moved to the Transatlantic Economic Council, but not all of the topics are part of this. And the European Parliament colleagues, like from the US delegation, are actually an intensive part of this dialogue, which is more government-driven. Nonetheless, it has a very intensive legislative component, which will be in the future even stronger. With this, Catherine, please.
Thank you, Erica. I just want to give you an overview of the key moment in which we are in European Union. Why? Because we are very much touched by the crisis, the financial crisis, and it's very difficult to find new growth and to support the creation of jobs. So we think that one of our biggest and important tools is really the unique market. So what we can do is to take initiatives to simplify and to give a good framework for intellectual property, because of course intellectual property gives the basement for the capacity to have new products, to have new processes, and to answer correctly to the challenge of digital economy. So the Commission has adopted for that a comprehensive strategy to revamp the legal framework in which IPR operate. So you will see that there are, it's an extensive, proposal. We have several steps, and I want to propose to go through this overview with three dimensions. First, what we can do for the unique market and the importance of intellectual property. Second, as we said, Diabolo is in details, and how copyright the reform on copyright can succeed or not. And third, what are the international consequences of this? First, the IPR. In the proposals of reform, there is one very key issue, which is a unitary patent protection. And of course, this is very important because it was an occasion of division between the member states. And we have now a solution to have this unique European patent, which is the reinforced cooperation between a majority of member states who decided to work together and to go through the question of linguistic exigence. So they decided, and we supported it in the European Parliament, to work on the definition of this new patent with the reference to the Munich office, with the three languages which are used in Munich, that is German, English, French. So it was some member states were angry, as Italy and Spain, but they didn't want to enter the reinforced cooperation. But this is going on. The second aspect is the creation, which is now in discussion, of a jurisdiction for this European patent. This will be very important to diminish the costs and to have a real stability in the case law and in the judgments about litigation. So we hope that this will create a legal certainty with this new court. Third, we have on the table the modernization of the trademark system in Europe. This is less controversial. There is no question. The question of language was solved 15 years before, and now it's just a modernization of this trademark system. So I have no specific remarks to express about that. The Commission intends to present proposal this year still to modernize the trademark system, and of course it's also a necessity to adapt this system to Internet era, and we will look on the transborder transatlantic also issue. We have next the creation of a comprehensive framework for copyright in the digital single market. This is more difficult. So where are we now? We convinced that we need to write a new copyright system. We agree on the fact that copyright is necessary. Copyright is the way to give, the economical counterpart for a creation. And we need to find new business models and to help the capacity to answer to this two-side, situation. We could live as a sort of conflict, the interests of the end users of Internet and the interests of the companies and especially cultural, industries, as music industry. The problem was that the conflict began with a false question. The false question was from the music companies. They said, we lose money. So we need to sanction piracy. And the consumers said, look, we don't have the correct proposals offer. So change it. The problem was also on a juridic point of view, and I work with many specialists in Europe. We didn't give a definition for what is piracy. Just counterfeiting, a compartment with a big downloading activity, or a commercial intention, that is to sell irregularly, illegally, some cultural products, distributed by firms. So this was a very huge discussion. And so the answer in France was the three strikes system. Sanction, cut the access to Internet. Fortunately, because of our debate on the regulation on telcos, we could say that Internet access is a quasi-fundamental law, because you have your identity, you have your communications, you can have urgent emergency, you can have education, formation, many things which are necessary, and one action cannot cut you if you use Internet of all the other activities. Fortunately, the Constitutional Court of France was completely okay with the issues of the European Parliament. And they took the conclusions and they censor the French law. I see in the system of copyright alert in United States a more wise answer, that is with 5, 6 announcements for the user, but with also some questions I want to raise because of this solution. This solution was decided between companies and the public side and the legislator. But I didn't see that the organizations of consumers could sign this alert system. And I cannot see who is the independent reviewer when there is a problem. I I see also that there is a right, which is a right not clearly with no clear definition, which is the right to scan from the owner's right the network to see who is downloading illegally and who must be, seen on the web. And I think that some aspects are not totally clear. But if I see the situation in Europe, it's the same. We have the three strikes law in France. The independent authority has a problem. During month and month, they had to see if the technological tool to look on the traffic could be accepted or not through the French law. Imagine. So when they did this, we had a legal commercial proposal, so the piracy diminished automatically. So now the activity is not so important. It is important, but it's not so important. But we have still, some economical consequences, as in the US and other countries, by a real piracy that is an intention to take off from the legal market some products. So this is a reality. I don't want to say that there is no reality for that, but we need to have a real vision and clear definition on what is really piracy. So UK adopted a bill, an digital economy bill. The Spain got the CINDE law, which was hugely contested. So we are now in this situation. This is still a difficulty between member states to have a real common vision on the system of copyright. The solution proposed by the Commission is to work on the multi-territorial copyright licensing. And we just finished and we adopted the conclusions of our work group, which worked during 2 legislatures about the reform of copyright system. It was adopted on the 29th of June, so you can find it if you want, if it's interesting for you. So we think that we must go to an efficient multi-territorial collective management of copyright, and we need also to have common rules on the transparent governance and revenue distribution. That's why this reform will include also the reform of the organizations of gestion of rights, authors' rights. So this is the orientation. We have also a text on the orphan works, but this is not controversial because orphan works, it's the capacity to put on the net some works which are in the public domain. So this is a sort of simplification of the access. So no question on that. Now, on the international aspect, because we had this question about the situation of the reference to Internet and access to Internet as, a fundamental right, we can see that it changes also the definition of the Commercial Act. When before you bought a CD, a DVD, a material, a concrete object thing. But now it's the access, which is the possibility to have, your preferred music. So this is quite different. So we have to see a second point, which is very difficult, is the role of intermediaries. This is a key issue between United States and European Union. Why? About net neutrality, and I could listen during these exchanges in this dialogue of this year, that in the United States, net neutrality is not the same issue for the Congress, for the House. They don't use the term. I understand. It's very controversial. But the problem is that through net neutrality, we in the European Parliament, for example, we refused the responsibility of ISPs. Why? Because ISPs can be just the arm of a system which is a system of observation comparable to the police. And this is an intrusion we cannot accept from the member states and the governments, or a role of ISPs which cannot be just accepted. So I must conclude. And I want just to make the evocation of the Protect IP Act. This initiative perhaps is not will not attain a real decision in the House here or in the Senate, but it's very dangerous for us because it's the capacity, of course, to intervene outside the borders of a state if there is a controversial website which can be considered as illegal in the first member state, in the first state. So the European Union is very anxious that, for example, the American decision can be to close a website situated in one of our member states. So this could be assimilated to censorship, but censorship decided by a state with which we have some agreements. So we have not finished about the discussion on the international level, and this initiative of Protect IP Act is a sort of difficulty, even if it's not a bit provocative, in the moment in which the European Parliament must finish the examination of ACTA and take the decision. And as you know, Mexico, the Senate of Mexico, decided to vote against. So it's a difficulty. We have to finish with this difficulty. But I think if we can write the correct references in the reform of copyright, we would have a tremendous good situation for our common vision of the market.
Thank you so much, Catherine, for this complete overview. Let me give the floor to Marietje Schaake. And please, Marietje. If I just can remind us, I'm really sorry for this, we have 20 minutes left because we really have to finish at 11 o'clock.
I'm going to talk very quickly, so bear with me. I do want to thank the chair, the EIF and the Congressional Internet Caucus, and wanted to let you know that there's also an intergroup on new media within the European Parliament, which I founded, and if you want to have more information, happy to share. Okay. We're here in the context of the transatlantic relation, and that is based on our shared values and history, and I want to touch briefly upon how these shared values play out online. This session is about IPR, but I'll specifically focus on copyright in the context of the digitized era. And perhaps you can help me answer a few questions to start a debate. If we see that the fragmentation of the European digital market and sphere effectively buries its cultural content, while at the same time the words protection and enforcement are the most often mentioned in the recent communication of the European Commission, what does it mean for the chances of reform and harmonizing the system? Both US and EU-based companies know that the need for harmonization and the completion of Europe's digital market is vitally urgent today. Erica just mentioned the report written by UK Professor Hargreaves, which actually speaks of the dominance of so-called lobbynomics influencing the entire IPR debate and the assessment of the scale and impact of piracy and the need to have scientifically objective facts as a basis for policy. The assessment of damages is leading a lot of the debate instead of, for example, the potential and the opportunities of the digital era and the need to reform and the potential that that reform might bring about. Vested interests in relation to economic value are changing, and new players on the market are becoming more and more influential, and I'm sure that these will impact policy. Now, does the fact that digitized content is divisible, produced and distributed almost free of cost, lead to new business opportunities? And does this mean that the way in which we deal with counterfeit, so tangible goods, should be different from the way in which we deal with the sharing of digitized content? In order to allow for prices to go down, audiences to be reached, consumers to have more choice, etc., even if this means that intermediaries or middle players who have historically enjoyed monopolies on production, distribution and profit models lose out if they don't innovate. Should government work on reform if barriers of a legal nature stand in the way of competition, of artists reaching larger audiences, of allowing small and medium-sized enterprises and other new actors to enter the market. Could it be that the principles of copyright law that were developed or that was developed in the time of the printing press still stand, but that we must rethink their organization and management in today's day and age? I believe that if we want to maintain these core principles of copyright, but also of competition, online and offline, we must reform. In a globalized world, we are stuck with law and policy making on the nation-state level. Also, in a connected world, everything influences everything. But still, governments have to defend the human rights and fundamental freedoms of their citizens, which have been mentioned in this panel for numerous examples. Proposals of self-regulation should be critically assessed from that perspective. Which powers are given to commercial and private actors, and which main responsibilities are still in the hands of governments. I would like to end with a confirmation of my firm belief in the shared values between the EU and the United States, and I sincerely hope that we are credible when we work together and jointly speak, and that we can lead by example. The developments of the Protect IP Act, which Catherine Trautmann has already mentioned, lead to serious concern. Intervention and the takedown of websites in other countries would be a game changer. It would make the US non-credible when a country such as Iran or China takes down websites such as Twitter, Facebook, or Google, because they might endanger national security. They might spread content that's undesirable, illegal in that context. So with what credibility can the US then speak out against other countries involved in such practices? I think it would be a shame, and the EU would hate to lose the credibility of its partner in that way, and would hope to work together with the US on IPR issues and on the flourishing of our markets and well-being of our citizens. Thank you.
Thank you, Marietje, please.
So I'll try to be quick so that we get to the Q&A. As I indicated in the privacy session, under the Obama administration, we're in a period of ferment. We're enjoying a period when policymakers within the administration are coming together around tough challenges that have lingered for a while to figure out if there are new policy directions. And I would say that within the intellectual property realm, that is true as well. Rather than go through a long list of how we are taking a fresh look at how we enforce intellectual property rights and how we enable the digital economy, let me just point you to a few other references. Within the past month, we have released an update of the work of the Intellectual Property Enforcement Coordinator. So starting with the Obama administration, we have a new role within the U.S. government, the IPEC, Intellectual Property Enforcement Coordinator. And Victoria Espinel is the first holder of that office. A year ago, she released a strategy for improving enforcement, and just this past month, she issued a summary of many activities that the administration has undertaken over the past year to improve enforcement. As we go about this work, we recognize fully that we are seeking, in many respects, to have it both ways. As we all know, for many years, the conversation around intellectual property in a digital environment has been portrayed as somewhat of a dichotomy, that you either have it one way or the other. You either have strong intellectual property enforcement, or you have vigorous, fruitful innovation in the production of new application services and copying tools. And as in the privacy realm, the administration's view is that in some ways we should cut through those dichotomies and recognize that there may be ways to have it both ways, that we want to sustain innovation and we do want to, in a healthy way, protect intellectual property. And so how are we doing that? In some cases, new legislation is indeed necessary, and the Commerce Department in particular, with the backing of the White House and others, has been very aggressive in pursuing patent reform, and we are very, very close to having, for the first time in years, an update to our patent law. We can get into that in the Q&A if people like. Similarly, there may be instances where the copyright law needs to be adjusted as well. And here we recognize that the Protect IP Act is an important step. It's an important step put forward by Congress. I'll disappoint people in the audience by saying up front here that there is no official administration view on the details of the Protect IP bill, but we do look forward to working with stakeholders both here and overseas as we bring our views together as an administration. But then also importantly, this is a space where collectively, both in the United States and overseas, we believe there ought to be promotion of multi-stakeholder driven solutions. So for example, within the past week in the United States, the major internet service providers and the major content companies did come together and announce a memorandum of understanding under which the two sectors will collaborate to crack down on the most egregious online pirates that are exploiting their broadband connections to commit rampant acts of piracy. And that type of multi-stakeholder solution, we believe, ought to be encouraged because it gets at some of these nuances that are very difficult, like in the privacy space. The multi-stakeholder approach, we think, can get at some of these nuances that we think are difficult to draft regulation and legislation around.
Great, thank you so much. Who would love to go ahead? Please, don't disappoint us. We are hurrying here. Please, the gentleman there.
Good morning, my name is Chris Israel. I'm the American Continental Group here in town. I think this is a tremendous conversation and certainly underscores the huge necessity in terms of sharing information and making sure that we're very well aware of the variety of proposals and approaches to addressing these important, particularly these important intellectual property issues coming from our two very sizable markets that are very dependent upon our intellectual property industries to drive our economies forward. Some of the comments I do think underscore that need for ongoing education and the continuing sharing of information, particularly in regards to the Protect IP Act. And I think it puts an onus obviously on the United States and those in congressional leadership who are proposing that idea to share information with others in Europe and other countries, because I think some of the characterizations of the Protect IP Act that were made this morning fall a bit short of what some of the specifics of the proposal would actually do or seek to accomplish. They would come nowhere near, I think, allowing the United States to seize foreign websites or intervene with foreign websites or activity that's going on in other countries. That certainly would not be something that this country could put itself in the place of doing. I do think when you talk about the notion of allowing government agencies or private rights holders to seek a remedy in a U.S. court that allows them to work effectively with an intermediary like a payment processor or an ad service provider to disallow or get in the way or interrupt the commercial activity of rogue websites that are blatantly interfering with and infringing on intellectual property. That's a completely different conversation and a much more a conversation I think that is very germane to the dialogue between the United States and the U.S. So I think hopefully we can move beyond some of the misinterpretations of the Protect IP Act and what is actually trying to accomplish in a very targeted and specific way to attack what is a very big global problem, particularly for our two economies.
Thank you for the clarification from your point. I take the gentleman here. I don't think so. There's somebody wants to make a comment on this one. I think we continue, and then I go back to the panel.
Thank you, Thomas Pilar with ICANN based in Brussels. I just want to make one point that is actually relevant, I believe, for the US and the EU as well. And I come before ICANN, I come from the private sector, so I understand what IP is. I understand the risk and the benefits as well. I just want to say that when policymakers on both sides of the Atlantic discuss about your initiative and the one in the Parliament as well, please also keep in mind the overall stability of the Internet and the overall need for, because there is a global audience, obviously, and if you start to, here and there take down on other type of similar measures, this will have an impact on the way the global internet is governed, because other countries, as Catherine mentioned, are looking at that as well. So it's there is not only a EU or US impact, this will have a more global effect as well. Thank you.
Thank you, Thomas. The concern, I put on my icon hat, the concern is here that because the Protect IP covers some language, that a .com and a .net, everything which relates, all the companies which relate to it globally, will automatically fall under US jurisdiction. This can have some kind of extraterritorial effect. Now, it might be all misinterpreted, and we are very early stage of reviewing this, and I think we have taken your point, but I think the most important is to stay in discussion. Because we, from ICANN, we received the white paper, which was delivered by a team of engineers, which really looked at it and said, hey, be very careful, whatever you do, don't actually get it wrong with the internet route. So it's just a plea to work together and to get it really right, whatever we do. I have you always signal me if you want to intervene, otherwise I just go on.
Yes, thank you. My name is Justin Serafini from Height Analytics. I thought some of the discussion on responsibilities for intermediaries was very interesting. Two questions I have is about revisiting some of the provisions of safe harbors for intermediaries as far as our responsibilities toward content holders. The eBay decision recently in the European Court of Justice was very interesting. We still also see the YouTube Viacom lawsuit being appealed. I'm just kind of curious if there's any discussion on whether or not any of the policy there needs to be revisited.
So the role of intermediaries, what I love about this space is all these issues concatenate together, right? You move from privacy into security, you move into copyright, you move into the role of intermediaries, and you can both talk about policy in a specific space, but you can't ignore the related spaces. What I would recommend to you in terms of understanding what I think is a pretty good articulation of the common view as between the United States and the EU, and with other developed countries, in fact, is the recent Statement of Internet Policymaking Principles issued by the OECD. Coming back to my theme here, I do believe that we are in a period of ferment around internet policymaking, and that OECD statement is another manifestation of this period that we're enjoying, and in that is I'll grant you a high-level statement about the important role that intermediaries play, and the importance of making sure that intermediaries continue to play that important role by virtue of not being saddled with excessive liability or threats of liability. So, I would point that out as sort of an overarching statement of principle shared among developed countries. Then, however, you have to get into the nuances of individual circumstances, and you know as well as I do that sometimes those play out in the courts, sometimes they play out in regulatory proceedings, as I indicated. They can also play out in a productive fashion when you have the stakeholders in a room talking about how they might wrestle chronic issues to the ground and working on shared solutions.
Thank you. I wanted to respond to the gentleman who suggested more education on our side, and I'm always happy to be more educated. But as part of my education about this bill, it strikes me that 100 or more law professors have voiced criticism and concern that it might be unconstitutional in the US context. The bill quite literally aims, and I'm quoting, to deny access and linking to, quote, pirate or, quote, rogue websites, especially those registered outside the US, which are dedicated to infringing activities. And then we also see that a number of think tanks, but also companies such as Yahoo, eBay, American Express, Google, or Reporters Without Borders, Human Rights Watch, are concerned. So that's just a little bit of context also in terms of the different players in this field. Then on the OECD statement, I think we must, in light of this education and inclusion of players at the table, reach out more broadly than we do perhaps. And as policymakers we should certainly do that, but I would also invite American counterparts and business actors to do so, because this OECD statement, which is presented by some as an inclusive and valuable document, has been rejected by all civil society actors who are joined, or a major group of civil society actors who participated in this meeting. And I think that's regrettable, because then there's a split between civil society actors, companies, and politicians who are trying to deal with issues of shared concern online. So somehow we must come to more inclusion, and also when we're dealing with laws that impact people in third countries, while we are responsible for making decisions, I think we should also at least talk to people in those third countries to assess the impact on the other side.
If I could just make one comment on the OECD Statement of Internet Policymaking Principles. I wasn't there in Paris during the conversations, so I can't speak from firsthand knowledge, but the reports I received back from my colleagues from the U.S. government who were there and who did participate in the discussions were disappointed in the end that certain portions of the civil society decided not to endorse the document. I would, based on what I know, there were a substantial number of civil society organizations that did endorse it, and from what I understand, those that expressed their dissatisfaction by refusing to endorse it were disagreeing, expressing their disagreement with one section, in particular the intellectual property section. And so it's just indicative to me of how these dialogues tend to play out over the course of time, and how much IP, frankly, can be a hot button issue, right? We see that here even. To me, it's unfortunate that this overarching effort to come up with a holistic menu of principles for some was seen as unsatisfying because of a particular element. You know, from my personal perspective, it would have been nice to see a general endorsement followed by a caveat instead of sort of a walking out of the room because a certain provision wasn't formulated in a particular way to the liking of certain elements of civil society. But that's the way these dialogues go sometimes.
Yeah, that's how life is. Ivailo Kalfin, you wanted to make a comment. Ivailo, I introduced you already at the very beginning, although you couldn't come earlier. I know that you were in discussion. So please keep in mind, we're really running out of time because you want to go. You want to go to New York.
I'm not going to go to New York, but I'll keep it. Thanks a lot. Just 2 comments on to jump into the discussion. First, definitely the internet service providers have to have their responsibility, but this has to be a responsibility for assisting the law enforcement agencies. They cannot have a responsibility by themselves, because let's think, we are not talking about IPR only. I mean, if we take all the issues of cybersecurity, that would mean to ask from the internet service providers to watch the whole content, to make decisions, to limit access, to interrupt the use of internet. I mean, this is first technically not possible, second absolutely not based on any ground. So whenever we look, and I think also that they need to have a role in the law enforcement, but this should be a subsidiary role after the law enforcement agencies start working, and then the internet providers have to help on that. And the second thing is just a small example to show that sometimes it's really very, very difficult to apply the existing rules of intellectual properties. I have produced a very short, I'm making a campaign in Bulgaria for easier recognition of diplomas received in the European Union. I have produced a short animated movie, 1.5 minutes. First, I tried like hell to find somebody to buy some music for this to this movie. I spent quite a lot of time. At the end of the day, it happened that I have to pay again for 1.5 meetings, few $1,000s for the price of a piece of music. Originally it was Pink Floyd, then for Beethoven it was cheaper than that, but this is few $1,000s for 1.5 minutes. And you spent a number of weeks searching how you can do that. So if we want to apply the intellectual property rights, I really agree that education and availability and accessibility should be also there. Thank you.
Okay, thank you so much. With this statement, we come to an end. What I would like to do, and please join me in thanking the speakers. I think they did a great job. And we are joined by James Elles at the very end. James Elles, as I mentioned in the beginning, co-founder of the Transatlantic Policy Network, founder of the Transatlantic Policy Network, and co-founder of the European Internet Foundation. And I'd like to thank Tim Lawden and his team from the Congressional Internet Caucus, and I'd like to thank from the EIF, Christina Monti and Peter Linton. Well done, great job, and thank you so much. Have a great day.